Hey, good evening, everybody. That was a quick cut there. I'm Nate Eaton. Welcome to Courtroom Insider. We are in a new studio today, and Jordan is hiding off camera, but he can stick in his arm and wave. There he is. Jordan has been spending months putting this together. As you can see, it's here in a tiny corner of our newsroom, and we hope to bring you much more programming here on Courtroom Insider, but other things too. And it won't just be me here, but other members of our team will be here. And today we have a lot to discuss about the Lori Vallow trial in Arizona, which starts in less than a week. Jury selection begins Monday, and there's a lot that it sounds like a lot that needs to be done. I'm Nate Eaton. Thanks for being here. Let us know where you're watching from if you have any questions. We have a full docket today. Here's what we're going to be talking about. As you can see here on this screen, we have Lori's new motion to dismiss the case, why she says the prosecutor has been doing some bad things in Lori's eyes. Plus, we have the prosecutor's response. We have the state's witness list. We now know who the state is going to call at this trial. We heard about Lori's witness list that came out a week or two ago. Well, now the state has released their list. Lori has filed a motion to exclude witnesses from the trial. I have state's witness list on there twice. As you can see, we're really going to cover the witness list just to be sure you know all the witnesses. More filings from Lori, the trial schedule, what happens next, and in just a few minutes, Peggy will be here. Peggy, our comment moderator that many of you have never seen or met, we're going to bring her on. She's going to join us here and tell you how you can stay up to date on the trial. And if you have a question about the trial or whatever, information you want about the Lori Vallow trial, she'll be here to talk about it. So, a lot to talk about tonight. These are just some of the motions that we're going to go over that Lori Vallow Daybell has filed and that the state has filed. There's a lot. And normally, well, I shouldn't say normally, in the previous case in Idaho, most of these motions were filed earlier. Actually, I shouldn't say that because Lori Vallow wasn't representing herself. It seemed that a week before trial, most of the motions had been filed and were done. And that seems to be there's kind of a last minute rush here with these filings. Mainly all because of Lori Vallow representing herself. She has filed motions that she believes, the trial should be dropped, that certain witnesses shouldn't be allowed to testify. But remember, she also does not want to waive her right to a speedy trial. She wants this trial to happen right away. And it is scheduled to start, as I mentioned, jury selection begins next week. So let's jump into the first filing that we're going to talk about today. This was the motion for her to dismiss Trina Kay, the prosecutor, for misconduct in Lori's eyes. You can see here, the defendant, Lori Daybell, hereby requests that both case numbers listed above be dismissed for prosecutorial misconduct committed by the state's attorney, Trina J. Kay. So she mentions two cases. For those of you not familiar, the case we're talking about that goes to trial next week is the death of Charles Vallow. She's facing a conspiracy to commit murder charge there. A separate case is the attempted shooting of Brandon Boudreaux, her former nephew. That one will go to trial in a few months. She's saying that Trina Kay, who has been the prosecutor on this case with Maricopa County, should be dismissed because, in Lori's eyes, she says it was all about prosecutorial misconduct. So what does she allege that Trina Kay did? Well, we have it right here. On or about September 6, 2024, Trina Kay directed the Chandler Police Department and the Gilbert Police Department to refuse to provide public documents to the defense, interfering with the defendant's right to conduct an investigation. So Lori's saying that she wasn't given documents that Trina told the police departments, Gilbert and Chandler, to not give her documents. So that's the allegation in count in number one. Number two, on or about January 30th of this year, Trina Kay obtained and distributed attorney-client privileged communications between the defendant and her appellate attorney in Idaho. Lori is saying that Trina Kay got information that she shouldn't have, messages or communication between her attorney here, who's handling her appeal, and Lori herself. And number three, that on or about March 11th of this year, Trina Kay gave legal advice to defense witness Nate Eaton in a, quote, off-the-record conversation regarding how to avoid being served with a subpoena from the defense. Ms. K has personally thrown her ethics and duties out the window in order to win this, quote, high profile case in front of a worldwide audience. Lori goes on to say, because this court has ignored the state's conduct, Trina K became more blatant in her disregard for her ethical obligation. This is sadly similar to her longtime boyfriend, Juan Martinez's behavior in a, quote, high profile case years ago here in Maricopa County. It seems her behavior is not original. The court is obligated to discipline officers of the court for misconduct. This conduct is egregious and needs to be addressed by the court. The actions the defendant is seeking this court take are as follows. 1, removal from both cases. 2, sanctions. And 3, disbarment by the state of Arizona. So these are big allegations. Well, these are big penalties that Lori is calling for. And she's making it personal by bringing in Trina K's boyfriend. Juan Martinez was worked on the Jodi Arias case years ago in Maricopa County. Now, I want to tell you that, well, actually, I'm just going to let Trina K respond because that's exactly what she did. She says the state of Arizona, through undersigned counsel, requests this court deny her motion as there has been no prosecutorial misconduct. The state responds to each of the 3 allegations by noting that, quote, the facts as alleged by noting the facts by the defendant as to each issue. Number 1, on September 6th, the state became aware that the defense had made a public records request to the Gilbert Police Department. The state emailed defense counsel and asked them to request these items from the state. The state also requested that the documents listed in the defendant's public records request from Gilbert. So they requested these documents that Lori Vallow Daybell wanted. When the state obtained the documents the defense requested, the state disclosed them on October 1st as, I think that means date stamped pages, maybe it means bait stamped pages, 1000, On September 18th, the state became aware that the defense had made a request to the crime analyst section of the Chandler Police. The state was advised that the defense request was improper because it was made to the crime analysis section rather than going through the public records request process. So, sounds like the defense requested the documents but didn't do it the right way. The state was advised the Chandler Police Records Specialist section spoke with Laura Moyse, who sent a request for, quote, log records for all digital devices downloaded. The state was also advised that the Chandler Police did not know what was being requested as, quote, log records. Chandler Police Records Specialist advised Laura Moyse that when computer crimes detectives are involved in a case, their reports contain downloaded information on all devices from Chandler Police. All reports related to the download of Charles Vallow's devices had been previously disclosed to the defense. Additionally, all extractions related to Charles Vallow's device have been disclosed. So the state's saying what you're asking for, what you requested, they've been disclosed. You have them. On September 19th, the state filed state's motion for defense to comply. On October 15th, the court issued a minute entry denying the state's request. The state is unaware of any other public records requests to either Chandler Police or Gilbert Police by the defendant or her defense team. So Lori Vallow is claiming in that first point that they withheld evidence from her. The state is responding and saying, no, we didn't. The stuff you wanted, we gave to you, and there's nothing more. Point number 2. On February 6th, these are about the jails, the allegations that Trina K withheld or read attorney-client privilege between Lori and her Idaho appellate attorney. On February 6th, the state disclosed that jail calls made by Lori Vallow between October and January, as well as jail messages and photos from Lori Vallow's tablet from October to January. On March 18th, the defendant filed a motion to dismiss for violation of attorney-client privilege. The state is currently working on a response to this motion. The state hereby incorporates its response to defendant's motion to dismiss for violation for attorney-client privilege as part of this response. So it sounds like we're going to get something bigger on this particular issue. Issue number 3, the fact that Lori Vallow says that Trina K gave me advice on how to avoid a subpoena. This is how Trina K responds. On March 6th, the defendant filed a notice. The state requested that separate notices be filed for each cause number so the state would know which defenses and witnesses applied to each case. On March 7th, the state learned that defense noticed witness Nate Eaton is a reporter from Idaho. On March 12th, the defendant filed a supplemental notice. March 16th, the state filed a motion to preclude all witnesses on her supplemental filing. So that's a lot of words, but basically the state filed a motion to have the people on that witness list precluded, not included in to witness, to testify. At the final trial management conference on March 18th, the court heard from parties on this motion. The state advised that it did not have contact information for most of the witnesses. The state also advised that one of the defense witnesses, me, was a reporter. Nate Eaton contacted this prosecutor. I missed the page there, sorry. Nate Eaton contacted this prosecutor after court on March 18th, and this prosecutor called Mr. Eaton back. Mr. Eaton advised this prosecutor that his knowledge about the case comes from his interviews and investigation as a reporter. Mr. Eaton also advised that he had not been served with a subpoena by the defendant and he hoped to be in court for the trial. The prosecutor advised Mr. Eaton that even if he was not served, he still could not be in the courtroom if he was a noticed witness, and the rule of exclusion was in place. The prosecutor advised Mr. Eaton that this prosecutor would try to interview the witnesses and file a motion to preclude those that should be precluded at the end of the next week, which would be this week. The prosecutor did not advise Mr. Eaton how to avoid service of the defendant's subpoena. So what I can tell you based on both of those responses that Ms. K's response is accurate. For one, Lori Vallow Daybell said that on or about March 11th, Trina K gave me legal counsel. I have never spoken to Trina K in my life before March 18th. So that is wrong, on or about March 11th. I did say on Courtroom Insider that I had spoken with prosecutors and defendants. I did not say where those prosecutors and defense attorneys work, but I've spoken with several, not necessarily in Arizona or in Idaho or in other states. So we will see what happens with that. My hope and my plan, of course, is to go to this trial and to be there every day covering it. And there might be more to report about that angle coming soon. But I have reached out to the defense attorney, Lori Vallow, and the defendant herself, Lori Vallow, about what more they might want me to testify about, and I have not heard back from the defense team. Okay, so that's one file. A lot there on the witnesses and what we can expect. Now, let's jump over to the other filing that was had. This gives us kind of some insight on what the trial is going to look like. And we've got it up here on the screen. It's the state's amended final trial management conference statement. Basically, this tells us kind of what the state's going to do. Let's go through it. So here we have the state, the charges that the jury is going to be read. Let me make this bigger for you if I can. Whoops. Instead, I'll just turn it upside down. Okay. I think if I go over here. Well, anyway, I hope you can see it. Here we go. Maybe. Bear with me. There we go. The charges and the sentencing range for Lori Vallow is she's charged with one count of conspiracy to commit the first-degree murder. The possible sentence is life without the possibility of parole or 25 years. Life without the possibility of release on any basis until the service of 25 years. So the minimum will be 25 years. She could get up to life. The settlement status, there has been no offer of a plea agreement. There have been no settlement conferences that have happened. And are the defendant and state willing to discuss further settlement? No. So Lori Vallow is locked into this trial. If she wants a settlement tomorrow, it sounds like she's not going to get it. There will be 12 jurors and 4 alternates. The list of potential witnesses for the state, we have the list. From the Chandler Police Department, Daniel Coons, who's retired. Nathan Duncan, we have heard from him. He is a detective. He testified in Idaho. Marissa Francisco, Jason Hunsaker, Robert Crotham, he's retired. William McDonald, Nathan Moffat, we've heard from him as well. Ariel Werther, we heard from him. Erwin Weirbicky and Cassandra Younklin, we heard from her in Idaho too. From the fire department, Kent Keller and Scott Cowden, I believe we heard from them in Idaho, at least one of them. From the Department of Public Safety, Jeff Moberg. From OME, the medical examiner, Dr. Derek Baumgartner. From the Office of the Inspector General, Mark Sari, we've heard from him. From Banner Life Insurance, Robin Smith Scott, she's the custodian of records. So there's all of the officials that could testify in this trial. The civilians include Christina Atwood, Adam Cox, Nancy Jo Hancock, Serena Sharp, and Kay Woodcock. It's estimated the trial will take 5 weeks, and this is the statement of the case that will be read to the jury. The state alleges that on July 11, 2019, at approximately 7:37 a.m., Charles Vallow arrived at 5531 South Four Peaks Place in Chandler to pick up his son from the residence where his wife, Lori Daybell, was living. The state further alleges that Lori Vallow Daybell conspired with her brother Alex Cox to kill her husband, Charles Vallow, so she could marry Chad Daybell, and obtained money from Charles Vallow's life insurance policy and from Social Security. Special joy voir dire questions will be filed separately. That's where they go in and they question the jurors, and then juror instructions plus the original ones will be filed separately. So there you go. It's going to be 5 weeks. Could be less, could be a little bit more, but around 5 weeks. We know who the state's going to call, 21 potential witnesses. Lori Vallow, I think on her list, had 11. Well, but she didn't even include her expert. So that's what you've got there. Something to think about. And in a minute here, we'll talk about what the day by day will look like in court. Okay, now I want to go through some court filings that Lori Vallow has filed herself, more of them. You can see they're handwritten with her own pen in the jail cell, most likely. These are the ones that she wanted to file, where she says that these 3 people should not be allowed to testify. Their names are, as you can see here, Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. We request the state be ordered to exclude the following witnesses. Facts. The state's witnesses listed above are not for factual testimony. They are only here to offer speculation and hearsay. Then she goes on to quote some law, federal rule of evidence, that the witness has to have personal knowledge of the matter, and that the rule would prevent testimony of the subject if hearsay, because there's no personal knowledge. She's claiming that these people have no personal knowledge. She quotes a bunch of other case law, a bunch of other cases across America. And then she ends with the state's witnesses above. Let me see what that, I don't quite know what that word. The state's witnesses are meant to deprive the defendant the right to due process and right to a fair trial. These witnesses will not be testifying to facts, but opinion, speculation, and hearsay, creating prejudice and bias for the defendant in front of the jury. In conclusion, the defendant requests the above listed witnesses are excluded from testifying at trial, since it was discovered in pretrial interviews that these witnesses have been communicating with each other regarding the defendant and these cases. None of these communications between these witnesses have been turned over to the defense from the state. And it was discovered by the state, they're saying, or by the defense in these pretrial interviews, that much of the information these witnesses gave in their police interviews was gained from speaking to Kay Woodcock long before they were interviewed by police. All 3 of the above mentioned witnesses should be excluded from testifying at trial. Then the prosecution responded to that, to Lori's request to have them excluded. And here's what she said. Here's what the prosecutor said. The state of Arizona, through undersigned counsel, requests the court deny to exclude or preclude Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. Defendant argues in her motion that the witnesses are not there for factual, they're only there to offer speculation and hearsay. The defendant writes, among other things, that these 3 witnesses lack personal knowledge. The defendant seems to argue that therefore the witnesses are not relevant and should be excluded. And then it says, state presumes defendant means precluded. The state disputes these allegations and provides that these objections are more properly raised at trial, not by a pre-trial motion. The defendant is charged with conspiracy to commit first-degree premeditated murder. The state can use both direct and circumstantial evidence to establish that the murder was premeditated. The courts have long held that although motive is not an element of homicide, it is relevant. And then they quote case law. The state submits that the motive for this murder is that Mrs. Vallow, now Daybell, wanted to kill her husband so she would obtain the proceeds from his life insurance policy, Social Security benefits, and be free to marry her current husband, Chad Daybell. Each of these witnesses is relevant to establish premeditation and motive. The judge has not ruled on this yet, at least as of this taping. It's possible that he ruled on it late this afternoon, but haven't been there. All right, stick with me. I know these are a lot of documents. We're about halfway through. I hope you find this interesting. So that's what we have for the court documents that have been filed thus far. We have a few more to talk about, including this one, which is pretty interesting. Lori Vallow, of course, filed a motion saying, I want all the evidence. We talked about that a bit earlier. And she is now saying here that the state of Arizona, or the state is responding that the state has advised that it intends to admit evidence that the murder was committed for financial gain and to allow the defendant to marry another person. So they're going to argue that Lori not only killed Charles to get money, but so that she could marry Chad Daybell. The state will admit evidence to prove the murder was premeditated, it was pre-planned, and to show the motive for murder was to obtain the proceeds from a life insurance policy for Charles Vallow, Social Security payments for her surviving child and herself as a mother, and to allow her to marry the person with whom she was having an affair. Evidence of the premeditation and motive will be shown through witnesses and iCloud documents. The state will call a witness from Banner Life Insurance Company to show that the defendant contacted the victim's insurance company within 4 days of the murder of her husband to collect the proceeds she believed she was the sole beneficiary of. During this recorded call, she provided a different story about how her husband died by telling the life insurance representative that her husband's death was an accident. She told some people it was a heart attack, some people it was an accident, when really he was shot and killed. When the defendant learned she was not the beneficiary, she advised the person she was having an affair with, quote, so I talked to the insurance company, he changed it in March, so it was probably Ned before we got rid of him. They can't tell me who, of course, but it's done. I'll still get the $4,000 a month from Social Security. This statement by the party opponent about the life insurance is evidence of the premeditation. The defendant later contacted the sister of Charles Vallow to confront her about the fact that Charles Vallow changed his life insurance policy. The state will present testimony from an investigator with Social Security Administration and iCloud documents to show the defendant was aware of how much money from Social Security she would receive from her son JJ and herself as a result of the death of Charles before she went to speak with anyone at Social Security. This testimony and evidence further support that the defendant premeditated the murder of her husband. The state will present testimony from witnesses who were friends with the defendant and iCloud documents to show that the defendant used her religious belief system as a way to justify the premeditated murder of her husband, Charles Vallow. These witnesses and documents were disclosed to the defendant on December 12th, 2023, January 9th, 2024, and February 26th, 2024. So we kind of get a little preview there, a little trailer, you could say, of how the prosecution's going to take their case. We've heard a lot of this in Idaho, of course, and as we saw on the witness list, we'll hear from a lot of the same witnesses. We'll hear the phone calls in a couple days on Courtroom Insider. I think early next week, I'll kind of go through some of those calls and the testimony that we've heard before that will be played again, I believe, at this trial to help this jury understand what exactly was going on here in the lives of Lori Vallow and Charles Vallow and Chad Daybell. Okay, so now let's talk about some other documents Lori Vallow has filed about what she wears and how she is treated in the courtroom. She's had on handcuffs and ankle shackles every time, and as she said last time, a shock vest, which was kind of news to me. I didn't know those things existed, to be honest with you, but she has now filed a motion in her own handwriting again about what she hopes will happen at court, and that she wants to wear normal clothes. Let's dive in for this one. Lori Vallow requests this court wear civilian clothing during court proceedings, jury selections, and all trial proceedings. The public and prospective jurors are viewing the defendant's proceedings on worldwide media, hopefully just East Idaho News. Nah, just kidding. But you can watch it on East Idaho News, by the way. The defendant's appearance is, if in jail uniform, will constitute a violation of the defendant's due process rights. And then she quotes the Sixth Amendment. The state or Madison County's failure to adhere willfully or inadvertently would deny and violate the defendant's due process rights. Therefore, the defendant requests that the court order to allow the defendant the fundamental right to wear civilian clothing in all court proceedings, jury selection, and both trials. Then she files another motion. I'm just going to scan through it here. The defendant requests the court allow the defendant to have no restraints, handcuffs, or shackles while in the courtroom during all court proceedings. This request is made pursuant to the 14th Amendment, 5th, 6th, and 8th Amendment. On December 6th, the defendant was granted self-representation. It has been extremely difficult for the defendant to manage files, take copious notes in all pretrial hearings with handcuffs. It would be impossible to represent oneself at trial under these conditions. Also, the defendant's appearance in restraints, handcuffs, or shackles violates her due process rights. It impedes her ability to perform writing tasks in her defense. If the defendant is going to properly be allowed to, quote, defend herself, she must not appear separate or different from the state representative. To be able to stand, walk, move about the courtroom as the other attorneys is imperative in a fair trial. If any imposed Madison County Sheriff's Office restraints cause this defendant to appear to the jury different from the state's representation, it would violate the defendant's due process rights and the right to a fair trial. This defendant's documented behavior for the last 5 years while in custody warrants no restraints necessary during trial at all. This defendant has been through a long trial without any misbehavior at all. This defendant has only displayed stellar behavior all of the time that she has been in custody and incarcerated over the last 5 years. Therefore, the defendant requests that all security restraints be waived for this particular defendant. The defendant also requests the use of a pen at her trial table to take notes. At the minimum, the defendant requests this court to order the state and the sheriff's office remove restraints, handcuffs, and shackles for all trial proceedings, both trials. Well, Lori is right in the fact she has behaved at all court proceedings, and she didn't cause any issues in Idaho. She wasn't, I don't believe she was handcuffed in Idaho. I'll have to go back and check. I can't believe I don't remember. There's been so many of these hearings. If you were there, let me know in the comments if you remember. So here's the thing. The judge on these, the judge already ruled on the clothing, and he said she could wear normal street clothes during the trial and jury selection, but all other hearings she can't. She has to wear her outfit, from the jail. The sheriff actually responded to her request with this as far as the shackles and the clothing. The sheriff said the judge already ruled on the clothing, no use for, talking about it. But talking about having the handcuffs and the shackles removed, this was pretty interesting. The sheriff said, and let me pull this up over here. There we go. In the defendant's case, the sheriff's office has reviewed her request and recognizes that she needs to move about the courtroom. However, pursuant to policies and procedures and the sheriff's office duty to maintain control and custody of inmates and to ensure the safety and security of the courtroom, the defendant cannot go unrestrained. As such, the sheriff's office recommends the use of a rack vest and in addition to the detention officers in the courtroom during defendant's trial. And I think they mean an addition, like having more deputies in there. The rack belt is designed to temporarily stun an attacking detainee, thus buying time for courtroom security officers to react. The belt sits comfortably on the defendant with straps adjustable to a particular defendant's body type. The belt is not visible to the jury. Further, the belt works on a one remote, one sensor system, ensuring that activation of other remotes will not trigger the vest accidentally. These two security devices permit the sheriff's office to restrain defendants in the courtroom. Without any restraints, we'd have to recommend an unarmed detention officer and an armed sheriff deputy in the courtroom. And then the sheriff said, after reviewing her motion, I have the following recommendations. Normally, inmates attending a trial wear a leg brace and a rack belt around their waist, which allows detention officers to deliver an electric shock by remote control. These two devices are worn under the clothing of the inmate and are not visible to the jurors. Handcuffs, leg chains, and inmate uniforms are not worn while in the courtroom. She has been wearing handcuffs. And this is done specifically to prevent jury from knowing the defendant is currently an inmate. Okay, so it sounds like during trials, they don't wear the handcuffs. The jail staff maintain control and custody of the inmates during transports to the jails and all back and forth. Once an inmate leaves a secure jail facility, all inmates are restrained while outside the facility. In this case, they could remove the restraints while she's in the courtroom, and she could wear that rack, belt, and vest, which isn't seen from the jury, and a hidden leg brace to restraint to limit mobility. And yeah, so they're saying maybe, yeah, she can see she's not because she's her own attorney, she needs to move around. She might not need the leg brace, but there's no reason that she wouldn't need the rack belt. So that's pretty interesting. I did not know about this rack belt. I don't know if I've seen that in Idaho, but I'm going to check and maybe we'll do a story on what is a rack belt. And um, I don't know if it's like a taser, if you feel a little jolt or something, but obviously it's enough to kind of get the person to pay attention and behave and not run away, which you need these days in court proceedings because the you've seen it all the time. We saw it in that video of the guy in Vegas who jumped over the desk. I think it was Las Vegas and attacked the judge while she was on the bench. It was startling to say. Okay, 2 more motions, then we'll get to your questions, I promise, and Peggy will be here. Here's one of the motions filed by the state, followed by Lori. She is upset with the jury questionnaire, specifically question 12. Now, we have not seen the full questionnaire. It has not been released to the public, but apparently question 12 says, the state alleges on July 19th, 2019, at approximately 7:37, Charles Vallow arrived at a Chandler, Arizona residence where his wife, Lori Vallow, or Lori Daybell, and children were living. The state further alleges that Lori Vallow Daybell conspired with her brother, Alex Cox, to kill her husband, Charles Vallow. Lori Daybell denies this allegation. She bolded that and underlined it. The defendant would also like to bring to the court's attention that the state's final trial management conference pretrial statement was not a joint statement, and the state did not confer with Mrs. Daybell or any member of her defense team filing to this statement. The defendant requests that this court also require the state to amend the language in the pretrial where it states brief statement of case to be read to the jury to reflect the defendant's objection and suggested language. So that statement I read earlier that they said will be read to the jury, Lori is asking to include that line, Lori Daybell denies this allegation. I would imagine that's a reasonable request from her, and I could see maybe the judge putting it in there. Just to be sure the jury hears that up front, that she's accused of this, she denies it. Now, our last motion to talk about today, by the way, there were more. I didn't pull them all down. We'll save some for another day. This is a motion filed by the state to preclude defense expert Lonnie Dworkin and preclude noticed witnesses. So Lonnie is Lori's expert that she says will come in and evaluate all the cell phone information, the data that's on those phones and devices and whatnot. The prosecution made the point that we're getting kind of late here. The trial is coming soon. And the judge even told Lori, listen, you did not file this. You need 30 days. You're past the deadline. And she said it's been hard. You know, she did have some reasons why she did it. But now the state's responding and saying, no, he shouldn't be allowed. Here's what they say. They're saying that the state requests the court preclude Lonnie if the defendant did not comply with the rules. The state further requests they preclude all other noticed witnesses as the defendant has not complied with the rule. On March 6th, she filed a motion for both cases. The prosecution talks through many of the individuals were not counted by police, therefore the state cannot obtain information. The state has the right and an obligation to go through and interview all of the witnesses on Lori's list, but they couldn't find them. That was the problem. And the Trina Kay went through this at the last hearing saying, we went back and forth, and I'm not going to read all this, but basically Lori's investigator, Jeff White, emailed me late with some of the information. We didn't have the information how to contact all these witnesses. We just couldn't get through to them. And in this filing, it goes through to say that on March 13th, less than a month before trial, the state emailed defense investigator Jeff White and defense paralegal Anna Ramirez and asked what specifically Mr. Lonnie Dworkin was being hired to do. The state also requested the addresses and contact information for all noticed defense witnesses. Neither Anna Ramirez nor Jeff White responded to the email request. The next day, they emailed Jeff White and Ramirez requesting additional contact information for the witnesses. The state has not received a response. The state sounds like is trying to, get their ducks in a row for this trial, and the defense simply is not responding. And they're saying that the defense Lori Vallow did not comply with the rules by saying that you hire an expert. So she hires this expert, and let's say the judge allowed it in, and that the guy had time to go through all the data. The state, because the burden's on them, then has the right to go and have another witness examine what their witness found, the defense witness found. So they don't have the time for this trial that's happening in a week. And the state goes on to, detail the back and forth between them trying to get information from the defense lack of response, or responding, but not in a full and complete way. Also, they note somewhere in here, I read it earlier, I don't see it now, is that from what they understand, Mr. Lonnie Dworkin has not had any time to look at this. And we'll end it with the final paragraph. Trial in this matter is set to begin in 15 days. By the way, this was filed last week. The state will not have time to interview the 11 defense witnesses and file any appropriate motions in limine, nor will the state have time to interview the defense expert and determine if the state needs an expert to rebut what Mr. Dworkin will opine. For these reasons, the state requests the court preclude all 12 of the defendant's notice witnesses pursuant to Rule 15.7c violations. Again, as far as we know, the judge has not ruled on that. I am included on that list, so assuming the judge grants that, I would be not have to testify. So we'll see what happens there. Thank you for sticking with me on all those documents. Now, here's what you need to know. Coming up, here's our schedule going forward for the next couple of weeks. I'm going to click this button. Didn't Jordan do a good job with the studio, everybody? Just look at it. He painted these walls himself. Yeah, he did that. We're in a corner of our newsroom that used to hold file cabinets, and now we're broadcasting live to you all over the world. Here's what we've got coming up. Jury selection begins the 31st, and it goes through April 4th. Cameras will not be allowed in that. I'm going to try to get in, but from what I understand is if they need all the space for jurors, I'm not sure how that's going to work with media, but I'll still report as much as I can. We'll still do Courtroom Insider every day. On April 7th, it's opening statements. That's Monday. And then the trial is scheduled to run April 7th through May 9th. It could end earlier if it goes quicker, could maybe even extend a week, but those are kind of the dates to keep an eye on. Proceedings will begin at 10:30 a.m. Arizona time. That's 11:30 a.m. Mountain time. Live stream begins 30 minutes after court starts. So if you're in the Mountain time zone, I know many of you are, if you're in Idaho, the live stream will begin at noon, assuming they start right at 10:30. The judge has issued a 30-minute wait on all video that goes out in case a juror is accidentally shown or something happens that he doesn't want out. The media, all the media, this isn't just us, all the media have to hold the video for 30 minutes. But we will start live on our channel when court starts. It'll just be a standby graphic. So you can load it up in the background of your computer or your phone. And the second we can go live, we will have it for you so you can know that it'll be there and ready to go. Court will not be held on Fridays. So it's going to be kind of nice. A 3-day weekend for these jurors. And court will start at 10:30 on each of those days. Here's how you can stay updated. One, you can read live updates about the trial on eastidahonews.com. Now, we did this on the first trial. You might remember with Lori, where we didn't have cameras in there, and many of you wanted to stay up to date every day. And I posted live updates. We're going to do that again, and that'll be on my X too. But if you go to eastidahonews.com every day, starting at noon Mountain through about 5, I think, you can read updates. You can watch the trial on our YouTube channel. If you haven't subscribed, that would be awesome. And what do they say? Hit that bell button that I guess you'll get notified when we go live. Then you can know when we're live and when we'll have that court hearing for you. Courtroom Insider every night. It's going to be at 8 p.m. Mountain time. Normally we do it at 7. It's going to be at 8 because court's going to end a little bit later and I'll need a little bit of time to prepare. So 8 o'clock Mountain will be live every night. The trial's in session and probably on Sundays too to do a recap. And then sign up for our daily digest newsletter. If you go to eastidahonews.com, click on the Daybell section, click on Daily Digest. Every day at the end of the day, we send out an email that gives you all the Daybell news. If you really want all that, you can do those things, and that's how you can stay up to date. You can also find me here: Facebook, Twitter, X, Instagram, and East Idaho News on YouTube. Those are the channels and the platforms that will have all the information on this trial. And I'm happy to announce that on Thursday, here on Courtroom Insider, Colby Ryan, one-on-one, me and Colby. I have not interviewed Colby in depth ever before now. I've spoken with him 2 or 3 times briefly outside courtrooms, 1 or 2 questions, mic in the face type thing. I've texted with him, but we are sitting down for about an hour and nothing's off the table. And then the next night on Friday, I'm going on his channel. So we're doing a little bit of collaboration here where he'll come and talk to me, and then you can watch. He's turning the tables and interviewing me on Friday night on the Scar Wars podcast. So join here on Thursday, 7:00 Mountain. We'll have Colby Ryan, and then on Friday, we will have me and Colby on his channel. Okay, Peggy has been patiently waiting. Now, many of you have interacted with Peggy on our YouTube channel or our Facebook page. Peggy is our comment moderator. So Peggy, what exactly does that mean?
Okay, well, Nate, it just means that I kind of keep everybody playing nice in the sandbox together. We all come to the comments, and we all come with our own life experiences, our own feelings about a subject. Let's just remember to attack the problem and not the person. In other words, not each other. And I clean up comments.
She does. There's your word of wisdom for the day. Now, most of you attack the problem, not the person, she said. Most of you are fine. Most of you behave yourselves, but some of you don't. And that's where Peggy comes in. So where can people watch this trial, Peggy?
Okay, so I'm going to direct you all to YouTube channel, the East Idaho News YouTube channel. And that's where you can watch it live during the day, the trial, but you can also take time to leave a question there. If you want a shout out, you're welcome to ask for that. So I want people to know that not to take it personal. If I don't get to their question, I'll try my very best. Also, the shout outs, I keep track of who leaves, whose names I choose, so that I don't have the same person 15 times on a shout out, right? So,
and many of you have contacted us to say, why won't Peggy choose my question? Or why won't she give me the shout out? So just be patient. Leave your comment on YouTube. We're going to be streaming the trial every day. Peggy will jump in there and create kind of a community, which surprised me kind of honestly, Peggy, during Chad Daybell's trial, that so many people would wait for you to come in there. And I would occasionally jump in the chat and be like, hey, how you doing? Or whatnot. And people would look forward to interacting with really strangers bonding over this crazy case.
Yeah. Yes, that's absolutely right. They look forward to being together. It's a community, like you say. I look forward to being there. I can't wait for it to start. I will be in the comments off and on during those days, during the live streams. I look forward to communicating with you guys. We do have the best viewers in the world, Nate.
I agree. So, like the channel or subscribe to the channel. And then you can follow the trial and then stick with us for Courtroom Insider. Peggy, anything else you want to add?
I don't. Just remember to be kind, and we're all in it together.
Okay, we have a shirt coming out made in special Peggy's honor. It says, I come for the news, stay for the comments. And in a few days, I'll let you know how you can get it, because everybody, loves that. Peggy, good seeing you. Thank you.
Thank you.
See you in Arizona. Okay, bye-bye. All right. So with that being said, Peggy, we are going to let her go. And we have some questions. Speaking of questions that we talked about, actually, we do have some shout outs. So shout outs tonight. Jordan right here. He gets a shout out. He's going to wave again one more time. Look at my Hawaii background. That, by the way, that's not any tie to Chad and Lori. I was in Hawaii after the fact when I took this picture, and Now it's the background. Isn't that peaceful? Just look at it and pretend we were there. Jordan's here. I want to shout out Caitlin and Daniel and Nate and Rhett. They're in our newsroom and they've been so quiet during this. We're going to have to figure out a wall to soundproof it, but shout out to them. Rhonda is watching. Rhonda, thank you. Alex as well. Amy, Brian, Lauren, and Alex in Arizona, in Mesa. Thank you for watching. Kurt, Cheryl, happy birthday late. She had a birthday last week and I hope it was really amazing. Josh, Allen, and Gray, happy birthday. Not happy birthday. Thank you all for watching. Okay, a couple of questions here before we go. Could Lori face the death penalty in Arizona? Could she still get the death penalty in Idaho? No and no. The crime she's charged with in Arizona is not eligible for the death penalty. As we talked about earlier, she could get life in prison. And then Idaho's done unless somehow the appeal goes through and they have to retry her. That would be crazy though if that all happened. But no, she'll be facing life in prison. And once the trials in Arizona are done, whether she's found guilty or not guilty, she will be transferred back to Idaho. She's an Idaho inmate and she will serve her time here. Could Lori take a plea agreement or plead guilty at this point? Well, I would have said yes. I mean, maybe you see it in a lot of trials where, not a lot, but sometimes. My wife was on jury duty once. She got picked. And when the defendant walked in, he saw the jury and he said, okay, I want to take a plea. And it was done. So even though that statement earlier that I referred to from the prosecution said that that there would be no pleas going forward, maybe there might be, but I don't know. I can't speak for them. So and yes, she could always plead guilty. She could come out and plead guilty, and the ultimately the punishment's not going to change because she's coming back to Idaho. But I don't know if she's going to do that. Do you think you will have to take the stand to the witness stand? We talked about that earlier. I hope not. I hope not. I don't know what more I could add. I didn't witness this crime. And as the prosecutor mentioned, I have only reported what I've learned through my own investigation and through interviews with others. Will Lori testify? That's the good question. She's on her list to testify. If she does testify, then the prosecution can cross-examine her. And if she does testify, then she has to write out her questions and give them to her paralegal or her legal team, and then they will ask them to her, so she can't just get up there and speak nonstop. Why does court not happen on Friday, and why does it start so late? Apparently in Maricopa County, they don't do trials on Friday. They don't do court proceedings on Friday. It probably makes it much easier on the jurors, and it's probably starts late as well for the same reason, because a lot of people are it's such a massive county. It's so big that you have to travel in with traffic and getting kids to school and whatnot. It would be very difficult, I imagine, for most people to try to get there by 8 o'clock, 8:30, 9 o'clock. So they started at 10:30. They probably, in Idaho, they all met somewhere and rode in on vans together. And I don't know if they do that in Arizona. If you're there and send me a message. And that could take, meeting at 9 somewhere, picking everybody up, getting downtown, going in the jury room. So it could take time. My wrists will be very appreciative of that shorter day and the seats in the other courtroom were far more comfortable than in Idaho. So yeah. Could Lori be setting this all up for a big appeal? Perhaps she'll probably appeal any way that she can, but I would imagine, but I don't know how. The judge was very particular with her when she said she wanted to represent herself. Like, are you sure? Do you understand what this means? Are you positive? Blah, 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 blah. Have you heard anything more about Lori's interview with Keith? No, other than Keith did a podcast, I think it's called Talking Dateline, where he talked a little bit more about it. And they played a clip they hadn't played before about her loving Chad. And that was interesting to listen to, but I don't even know if she's seen the interview. So yeah. When do you leave for Arizona? Are you flying or driving? I'll give you a ride and we can talk about the case the entire way. LOL. Jordan, did you send that in? No. I am driving. I leave this week, and I am going to do a couple videos as I drive down. I'm going by myself. Going to pack up the car. Teton Toyota has been wonderful, and I'm taking one of their cars. They're helping us out, helping me get down there. So big thanks to Teton Toyota, Gray Augustus, and Mario. All those guys there have been great. So I'm going to drive one of their cars down, and I'll fill you in along the way. I'll probably stop one night. Maybe I'll go straight through. I'm not sure. So yeah, and thank you for your offer of a ride. I don't think I'll be talking about the case all the way down. But by the way, that reminds me, if you have a good podcast or music I should listen to, let me know, because I got to kill, I think it's 13 or 14 hours from here. If the original crimes happened in Arizona first, why are the trials happening last? Good question. So yes, the original crime happened in July of 2019, and then the children were killed, and Tammy Daybell was killed in the fall of 2019, and then Idaho went first. The reason being that the kids missing kind of took precedent over Charles Vallow, just because he wasn't missing. They knew where he was, and they arrested her in Idaho. They kept her there. I'm sure there was much discussion between all the agencies of, do we move her? But I think they wanted to go with those Idaho ones first because she was there. Chad was there. Chad doesn't face any. And remember, in Idaho, Chad and Lori's cases were combined. So it was going to be one big trial, but then they were severed. And then Chad doesn't face any trials in Arizona, any charges in Arizona. So that's probably why. Do you think if Alex was still alive, he'd be facing criminal charges, and would he or would he fall on the sword for Chad and Lori? Yes, I think he would face charges. I don't know if he'd fall on the sword for them. I've heard some theories that maybe he might rat on them, that he might turn on them. Seemed toward the end of his life, he was realizing that this wasn't all as it seemed to be. And Chad and Lori seemed to get rid of anyone that was in their way. And maybe he was in their way, perhaps. So I don't know. That would be the really fascinating, well, so many fascinating things about this, but one of the really fascinating things is if Alex was here, what would have happened with him? You ate a lot of Smarties during the trial at the other trials. What is your go-to candy this time around? That is a good question. I don't think I've had a Smartie since the last trial. I think I got kind of tired of Smarties. I've been trying to eat a lot better too, but I'll have to find something. Although with that shorter court day, I don't know. Maybe I won't need candy, but so many of you were so kind to bring me candy. And if I didn't eat it, guaranteed my kids ate it or my colleagues ate it. In fact, we showed up here one day. Well, I didn't because I was in Boise. So one of you sent a case of like Biddo honeys. And what was the other thing? Cinnamon bears?
Oh, yeah.
Cinnamon bears and Biddo honeys. And they were left on our porch here at East Idaho News. So thank you. Last question. Can you come over for dinner one night in Arizona? We'd love to have you. Well, thank you. Thank you. That must have been from someone very kind. I'll be honest. When I was in Boise, I didn't have dinner with one person the entire time. I maybe one night. I did one night with a friend. He came to town because I get in the zone where I'm in court. Then I prepare for Courtroom Insider. Then I do Courtroom Insider. And at that point, I don't really want to talk or think. And that's when I eat dinner. But thank you. That's very kind of you. And it may be because I'm just antisocial. I don't know. All right. Well, thank you so much for being here for Courtroom Insider. We'll be back Thursday night with Colby Ryan. Don't miss it. It's going to be a phenomenal conversation. Again, big thanks to Jordan for putting this all together. Now that I'm leaving, when I get back, we'll be doing more Courtroom Insiders from here. Maybe we'll have some of you on as guests. Let us know what you think of it. The beautiful Hawaii area there, and so much more to do. Again, I told you where you could find me. And if you have any questions, please send them in. And I hope you have a great night. Thanks for watching.